with Frank Verkuterin in Benham, Ontario.
The personal ads in at least one weekly newspaper are a little too personal for Toronto police. The department's morality squad laid 14 charges of soliciting in a public place against the weekly paper. Now, it is the first time such charges have been laid against a newspaper. The paper's business personals offer a variety of sexual and erotic services. Some even accept credit cards. Now's lawyer says that the charges go against constitutional guarantees of freedom of the press. And the paper's editor says that the ads act as a public service by taking solicitation off the streets. Roland Penner has some thoughts on the charges and the paper's claims. He's a former Attorney General of Manitoba, also the Dean of Law at the University of Manitoba, and Canada Live's legal columnist. Now, soliciting in a public place, illegal, I understand. How do you translate that to a newspaper placing an ad?
That, I think, is the great difficulty that the Crown will face. As we know, prostitution itself is not an offense, and soliciting for the purposes of prostitution is not just phrased in that way an offense. It has to be everyone who in a public place, as you just noted. Now, it seems to me that the real difficulty the Crown has is not on the constitutional issue, but on the question of whether or not an ad in a newspaper is a public place. And for everything that I know, in terms of how a place is defined in criminal law and in the criminal code, an ad in a newspaper is not a public place.
I suppose it depends on whether you put the emphasis on the word public or place. It is certainly public, whether a newspaper that you open is a place or not.
Well, clearly it isn't a place, and there's all kinds of law that would make that quite clear. And when they redefined the offense of soliciting for the purposes of prostitution, because of the previous Supreme Court decision which said there had to be an element of persistence, so they took that out, and there was a question of whether or not a conversation carried on between someone on the street and someone on an automobile, and so they included an automobile as being a public place. So it's quite clear that they addressed their mind to both aspects of the offense, place as well as public, and there was no suggestion that an ad in a newspaper would be capable of being defined as a public place.
Well, let's go to the other side. The newspaper responds by saying that in fact they are doing a good thing, that this is a benefit to society by putting these ads in a newspaper. Would that even come up in this argument?
Well, no. The court could not be concerned with very vague sort of arguments of that kind, arguments that tend to bring the issue into the moral arena, for one thing, rather than into strictly how is the crime defined. It is said in law that when you're going to inflict a punishment on anyone for doing something, you have to have that defined very, very clearly and carefully, and a person charged has to be found guilty of every element of the offense. And often definitions are key. And certainly, as I've said, place, or in another section of the code having to do with hiding something, receptacle, all of these things have well-known definitions, and I just don't know of any definition of place that would include a newspaper ad.
Well, we keep getting back to this, the definition of place. I mean, this is a huge question, or perhaps a silly question. Why was the charge placed? I mean, what sense do you make of it? Do you think it's got any chance of even being carried through?
Well, the newspaper now, I think it's called, is alleging that they're being harassed by the police because of stories they've carried about alleged police wrongdoing. Now, one doesn't know that, and one has to put that aside. I don't know why, other than sometimes the police respond to public pressure or the pressure of some influential groups. It may be that some of the moral guardians of society have been in touch with the police and have said that very explicit, and some of it is quite explicit, although apparently they can't make specific reference to specific body parts. But it's quite clear what is being advertised, and that it is for money and therefore is for the purposes of prostitution. But is it soliciting for prostitution, purposes of prostitution in a public place?
Just one final question. Is freedom of the press any kind of an issue here?
No, I think that the suggestion that the newspaper could defend itself by the relying on freedom of the press flies in the face of the most recent decision of the Supreme Court, one that is just a few months old, which in the case of in Manitoba said that while commercial speech comes within the general guarantee of freedom of speech, freedom of communication, freedom of the media, and so on, nevertheless, a limitation on that right is acceptable if it is reasonable in a free and democratic society. And they have said that the criminal prohibition of soliciting for the purposes of prostitution in a public place is a reasonable limit on freedom of communication.
Thank you very much.
Okay.